When disputes arise, do we always need to rush to courts? Or is there a faster, fairer, and more professional way to resolve conflicts? Today's article raises a very important question. Has India truly built an independent and effective arbitration council? I'm Dr. Nisha and Jacob from Care Gardens and Adolescent Counseling Cell, Alapura. Today, we are decoding a crucial legal and governance issue that affects businesses, professionals, and ordinary citizens alike. This article is written by Srimati Aratrika Bhaumik. She is a legal journalist and policy commentator known for her clear analysis of law reforms, judicial processes, and governance issues in India. The story begins in 2019 when Parliament amended the Arbitration and Conciliation Act of 1996. Through this amendment, the Arbitration Council of India, ACI, was envisioned. Its purpose was ambitious: to promote arbitration in India, to make dispute resolution faster and professional, to reduce the burden on courts, to improve India's image as an arbitration-friendly country. But 5 years later, the big question remains: has the vision truly been realized? According to the article, the proposed mandate of ACI included framing policies to promote arbitration, accrediting arbitral institutions, recognizing professional bodies, maintaining a repository of arbitral awards, and laying down standards for arbitrators. The institutional framework was based on recommendations of a high-level justice committee. The chairperson must be a former Chief Justice of India or a former judge of the Supreme Court or High Court. This shows the seriousness with which arbitration reform was initially planned. However, experts raised serious concerns. The biggest worry was government dominance. The Arbitration Council was perceived as being controlled by executive, lacking sufficient independence, and functioning more like a regulator than a neutral promoter. Experts warn that arbitration must be independent of government influence. Otherwise, trust in the system collapses. The article clearly highlights that most ACI members are appointed by the union government. This raises fears of bias, especially in disputes involving the government itself. India already has a large number of government-dominated arbitrations, delays, and credibility issues. Instead of fixing these problems, a government-controlled ACI may actually worsen them. In October 2024, the Union government proposed amendments to the Arbitration and Conciliation Bill of 2024. This draft bill aims to revisit the definition of arbitral institution, introduce structural reforms, reduce excessive regulation, give more flexibility to institutions. However, the concerns are about the exclusion of foreign parties, over-centralization, and whether the reforms truly reduce executive influence. Under the original 1996 Act, courts could grant interim relief before arbitration. Later amendments include limited court intervention, introduced timelines for arbitral proceedings, but still problems persisted. The delays in constitution of tribunals, long pre-arbitration litigation. The article notes a new proposal introducing provisions allowing interim relief even before the tribunal is fully constituted, addressing delays that harm parties financially. According to the article, meaningful reform requires reducing government dominance, strengthening institutional autonomy, encouraging professional arbitral bodies, and aligning Indian arbitration with global best practices. Without independence, arbitration becoming another bureaucratic layer. India may fail to compete with global arbitration hubs like Singapore or London. This article is important for everyone. It builds awareness about law, governance, alternative dispute resolution, and career paths in legal and policy fields. Efficient arbitration means faster justice, lower costs, and less court burden, affecting housing disputes, contracts, and consumer rights. A credible arbitration system means trust, investment, confidence, and global competitiveness. This article reminds us that institutions matter and independence is the soul of justice. I'm Dr. Nisha Jacob from Career Guidance and Adolescent Counseling Cell, Alapura. Thank you for listening. And remember, a strong nation is built not just on laws, but on fair systems that people trust.